Think an email can't transfer land? 2 lawyers, 2 emails, 1 almost sold house. Today, we are breaking down Waddle vs. Elrod, a case that had proof that if you email it, the court might enforce it. Welcome back. This is 99 Rights Online, where we decode the law so power isn't just for the privileged. We break it down fast, fiery, and fearless, because knowing your rights isn't optional, it's survival. Meet the Statute of Frauds. What it is. The Statute of Frauds is a rule that says some important agreements must be in writing to be enforceable. It exists to stop people from being bounced by shaky memories, he said she said stories, or surprise I never agreed to that claims. So here are a few common things it covers. 1. Real estate deals, buying, selling, or transferring land. 2. Promises to pay someone else's debt, guarantees and sureties, which you can think of like this: when the backup pays, guarantor; after default, surety, right away. And if you think of it in level of responsibility, guarantor, backup, surety, partner in responsibility. But remember, both should be in writing because they create third-party promises. Okay, so 3. Contracts that can't be performed within 1 year, long commitments. 4. Sale of goods above a value threshold, when big money is involved. 5. Promises in consideration of marriage, engagements and related bargains. Why it matters: if a contract falls inside the Statute of Frauds and there's no proper writing or signature, a court can refuse to enforce it, even if everyone swore on their mother's recipe that they agreed. It's the law's way of saying, show me the paper. So what happened? Let's get into it. Waddle claimed her niece, Elrod, got half a property by undue influence. On the eve of trial, the lawyers exchanged emails. Elrod would reconvey the property back to Waddle, or give her half back basically. So, Regent Investments. Yep, they've dropped the suit. Later, Elrod had second thoughts. But hold up. That was not the deal. Waddle sued to turn their email handshake into law. The core arguments the parties had were: Elrod said the Statute of Frauds bars land transfers without a signed writing. And Waddle said the emails, plus the legal description already in the pleadings, satisfied the statute under Tennessee's UETA, allowing electronic writings, signatures. So, what is the UETA? It is a law that gives electronic records and electronic signatures the same legal effect as paper records and handwritten signatures in most business, commercial, and governmental transactions. The court basically said, the rules say big money deals need to be written down. But watch out! Those emails, when you read them with the part that describes the property, they may count as a real written note. Because the law treats emails like paper signatures, and the deal was real, just like when you sign for a sale, but with receipts and a hidden joke. Legally, Waddle fuses old Statute of Frauds formality with modern e-signature law. It signals courts will enforce digital settlements that show clear and explicit assent and identify the land. Around our communities, it affects survivors, buyers, lenders, and title companies who face risk if informal emails bind property transfers, litigation, recording gaps, and surprise claims follow. Just remember, some jurisdictions insist on signed deeds. Others, like Tennessee, let electronic records and pleadings do the work. So our top 3 takeaways. 1. Treat that I agree email like a handshake. It might be the deal. 2. Emails can bind on land. 3. Use clear, deliberate language in settlement emails. So remember, Waddle v. Elrod equals: if it's in your email, don't hit delete, because the court gave the send button power. If this breakdown made the law feel a little less intimidating and a lot more powerful, don't scroll away just yet. Like, subscribe, and share to keep your rights sharp and your feed spicy, because justice isn't just for lawyers. It's for everyone. This was 99 Rights. Online, where law gets loud, clear, and viral. Subscribe for justice that hits different.